So this video talks about Scotland as a model for digital registration, which is something to live up to. But Scotland has a long history of registration. It's particularly got a long history of deed registration. The Sayesian Register was established in 1617, and it existed as the principal register until 1979. So that's 362 years. That's a long time in legal law. So, but the longevity of that is a testament to its fitness for purpose. But the Sayesian Register, as a register of deeds, wasn't a spatial register. Could have been, but it wasn't. And it was principally paper-based. So its indexing was very much based upon how you're trying to cross-reference paper infrastructure. Deed registration was reduced under the 79 Act in favour of a register of title. Now, the 79 Act introduced a spatial register, but over time, a number of legal issues were identified, which were reviewed, and new legislation was produced, which became the 2012 Act. This produced a register of deeds, title, and plots of land. And so, in response to the 2012 Act, there has been a reframing of the indexing components to establish legal certainty and efficient processing. And these slides go through this process. So, how did this change happen? 79 Act was a register of title, and so as Reed and Gretton in their nattily entitled book called Land Registration states, before the 2012 Act it was common to say, for instance, that the disposition by Tom to Mary was registered in the Land Register on the 2nd of February 2000. But the propriety of so speaking was questionable, since under the 79 Act, registration was strictly of interest in land rather than of the deeds. So, which vouched for creation, transfer, variation, or extinction, because the 79 Act was a register of deeds. It wasn't that you were registering the disposition, you were registering that Mary was the owner. The disposition relates to the deed. As a register of title, what you're registering is that Mary is the owner and that Tom used to be the owner. But the 2012 Act is no longer just a register of title. As Reed and Gretton state, under the 2012 Act, deeds are registered. But as well as being a register of title and a register of deeds, the register is, under the Act, also a register of plots of land. And it's correct to speak of land being registered. So there are a number of principal revisions under the 2012 Act. So the register is a trusted register supporting the acquirer. So as under the present law, a bona fide acquirer should be able to rely on a register supported by a state guarantee. This is essentially your mirror principle. You can trust the register. It's also having deferred interfeasibility to protect the seller. So the requirement of a seller in possession would replace the existing requirement of a buyer in possession. So it's no longer treating it like a register of title. So transactional error resolution should favour the grantor. Indemnity in that instance would be mud, not money. So the grantee, who under a register of title would get the land, would no longer get the land. And it also is about protecting the acquirer from fraud. So furthermore, and following the present law, an acquirer should be protected not only in respect of errors on the register, but also in respect of errors, forgery, for example, which affect the current transaction. So in this instance, if it was fraud, the seller would get the indemnity, would get the money, but not the mud. So what are the implications for indexing here? So theoretically, the titling concept can be decoupled into its constituent parts. We have the register of deeds. We are showing our working. So a copy of all deeds describing registrable rights and their spatial extents. This is equivalent to essentially a spatial Sayesian register, that register that lasted 362 years. And this means that the interpretation of the deeds remains with the parties, if you want to use the register of deeds. There is also a register of plots of land, and this can demonstrate the chain of title that manifestly demonstrates indefeasibility of ownership or leasehold, because we have to bring leasehold in because you can derive title from leasehold. So the interpretation of the deeds is appropriated by the registrar, and indemnity can be given over that appropriated component, that register of plots of land. And this is materialized from the Register of Deeds to create your chain of title, and the mirror and curtain principle hold in this instance. And then you can have your registration of title, and this would be to demonstrate benefits, restrictions, and responsibilities associated with the Register of Plots of Land. So we're almost treating this as a spatially enabled society. We're taking out the spatial set of ownership or leases that are held in our Register of Plots of Land, and we're applying that to derive our Register of Title. And so this is derived from the Register of Plots of Land. Indemnity for that is held with the registrar, but also from the Register of Deeds, where the non-ownership rights are represented. And we can use that to pull in any overriding interest held on other registered if they can be dynamically spatially indexed. So we're resolving a number of extant problems in using the deeds, plots of land, and title metaphors, and protecting ourselves along the way. We'll next talk about registration and indexing options in and around outside of Scotland.